The state's no cash bail law was supposed to go into effect January 1st. This was part of the Safety Act that passed way back in January of 2021, was changed several times throughout since then, just before the November election last year. They had a lot of debate about this, and then Democrats won. They came back for veto session, passed a change to allow for some people to be held behind bars pending trial, and whether or not they're going to have to possibly let a whole bunch of other people out with no cash bail. And now the question is in front of the Illinois Supreme Court after the Illinois Supreme Court on New Year's Eve put a stay on the law statewide, meaning it was not going to be in effect. And that was because of a Kankakee County judge that a few days before, at the tail end of 2022, declared that the state law to end cash bail was not constitutional, and that it violated the separation of powers, and that it's also violated the Illinois Constitution's Victims' Bill of Rights. And there were also questions about the procedure of how this passed, and that's a big debate and conversation that needs to be had, and deals with shell bills. It deals with whether or not lawmakers are giving ample opportunity for everybody to have input into substantive legislation. So there's ongoing questions about the procedural issues, but I think one of the big things is, of course, the question of the separation of powers and how the Illinois Constitution, according to state's attorneys across the state, believe that the state constitution clearly spells out some kind of bail provision. So what you have is the back and forth. The state's attorneys sued, dozens of state's attorneys from like 60 plus counties across the state sued to block implementation of this. And then you had the Illinois Supreme Court have to step in and say, okay, we have to make sure there's no chaos here, and let's just halt the law. Instead of saying that, cash bail can maintain in 60 plus counties in Illinois. Illinois has 102 counties. Instead of saying that it's just going to be a patchwork of counties that are allowed to have cash bail versus those that don't, we got to put a hold to this thing statewide. And they did that again New Year's Eve. So now we get to the point where you've got the briefs that have been filed back and forth with the state responding to the plaintiffs out of Kankakee County, and Illinois in that response said that the plaintiffs have a grab bag of constitutional theories that need to be rejected. So Illinois Attorney General Kwame Raoul leading that conversation. But I did chat with Patrick Windhorst, a state representative from Metropolis, who kind of shared with us a bit of the perspective of what the state's attorneys ultimately are arguing and what he expects to happen with the Illinois Supreme Court set to hear this tomorrow here in Springfield. So some pretty interesting stuff here coming up this week. Again, here's Patrick Windhorst chiming in a little bit on just how this could be playing out come tomorrow.
Well, as we and others have argued throughout this process since the Safety Act has passed, our state constitution envisions a cash bail system. We are going to hear arguments from state's attorneys, I believe out of Will and Kankakee County, who are going to put forward the argument that the ruling of the Kankakee County Court was correct in saying that the elimination of cash bail violates those constitutional provisions and also violates the separation of powers. The courts have the authority to operate and administer the court system. Bail has been held to be an administrative function of the court, and it's not something the legislature can impede upon. That, I'm anticipating, will be the argument of the state's attorneys in that case. Of course, the state has argued, the Attorney General, that the prosecutors can't even bring the case because they've not been harmed by the law. I don't believe their argument on the merits is strong. I think their argument is more toward a standing situation.
Well, and then I asked about the idea that you've got the possibility certain individuals who are innocent until proven guilty being picked up, arrested for a crime, and then, being let go because there's no cash bail. And how is that going to impact the safety of communities? Patrick Windhorst responding.
What we believe will occur with the elimination of cash bail is people will be released very soon after committing serious violent crimes, which is going to lead to an increase in the crime rate, an increase in recidivism, and a lack of accountability for those committing crime.
So that seems to be the arguments, and we'll hear those Tuesday in front of the Illinois Supreme Court. But again, it's going to be fascinating to see if two Supreme Court justices are going to be on that bench after getting $1 million from Governor J.B. Pritzker each. He's a top defendant in this case, just as he's a top defendant in the challenge of the Illinois gun ban. And we've seen instances of Illinois Supreme Court justices taking no part in cases before. It's not uncommon. You've also got the instance of a judge in the Southern District of Illinois removing themselves from a case out of questions of conflict. I mean, conflicts of interest. It's even the perceived conflict that can brew some kind of suspicion and challenge of a court's ruling on things. And if you have, especially at the Supreme Court level, those types of questions being raised, that's some substantial questions that could lead to a lack of trust in the judiciary, and that judicial integrity, I think, is something that's pretty important to a lot of people out there when it comes to this constitutional republic. So it's going to be fascinating to see what happens. We will be covering that in detail as well here with Springfield's Morning News. So wake up each and every weekday morning from 6 to 9. I'm here. You're here. Appreciate everybody for chiming in and hanging out. And we'll, of course, keep you updated on all of that and more here on WMA.